Welcome to the next instalment of the Odd Ansons podcast. I'm joined by Martin de Ridder, and today we're going to be talking about AI, the law and its implications. Today talking about AI and a subject that is very much on people's minds given the position of the government at the moment with talking about making the UK an AI hub. But what does that really mean?
Well, hang on, Jason. I'm going to stop you right at the beginning here. You love an acronym, and there might be some people who don't know what AI stands for.
Artificial intelligence.
Yes.
The use of computers to generate work effectively, or to be able to answer questions or do some of the functions that a normal human being might be able to do.
Yeah, and last week the Prime Minister sort of had a summit or some sort of speech whereby, as you rightly say, he wanted to make the UK one of the leading countries in which AI businesses or the use of AI could be implemented, and to see that as a big part of his growth strategy. So quite how, and we'll come on to quite how that, what we see that impacting on business and the law generally is something we'll come on to. But clearly we are going to see increasing amounts of legislation and regulation around this area, even if the government, as they stated last week's intention is to be very light touch, so that in contrast to some other jurisdictions, in particular the EU, which we'll come on to have a regime that isn't quite as onerous and as regulatory as some of our, I guess, other competitor economies.
Yeah, and it'll be interesting to see whether that's in the form of direct legislation or regulation, or whether it will be left to be secondary. So whether it's the regulatory bodies that pick it up, or whether it's done in a different way, or whether it'll just be picked up under other rules that are around. And again, we can come on to that in a little while. I guess the starting point, though, is not only what we talked about what AI is, but AI is creating all of this information, all of this data, all of these things that are going to be pumped out and used. I guess the first question is, well, who's going to own that? What is that going to look like? What does it look like? Ultimately, it will be the creator of whatever, the software designer, and as it stands, a lot of this stuff is being owned by Microsoft and ChatGPT because it's being fed into their system, and the works that come back are arguably there's some ownership there with the person who's raised the prompt, but in terms of what that is then doing on the system and on the databases that are owned by ChatGPT, a good chunk of that, and certainly the ongoing machine learning that is occurring, is going to be owned by the big tech companies, unfortunately. Yeah, and do we see the AI itself ever owning this?
Well, I think that's where people start to get very excited. There is some talk that because AI can make decisions, and whether it truly is making a decision, or whether actually what it is doing, and certainly with what they call the large language models, which is the ChatGPT and the Copilot, in effect, what that is doing is organising, having read thousands of documents, and it is in effect organising the words in an order that is useful to the person who's asked the question. So it can come up with a recipe because it's read thousands, millions of recipes. It can do the same for a poem or a song or whatever it is like that. And in some respects, there is no decision-making strictly that is occurring there. This is organising, this is following patterns to organise words. So I think as it stands, we are quite a way off what sometimes is called as general artificial intelligence. So where in effect the computer, the AI itself can make decisions independently, can I guess create its own works without being prompted to do some of that stuff. Now, there is some legal philosophy that occurs here, and some of those writers do get into, well, actually, is there a point at which it crosses over where a machine has got general intelligence, at that point, with general intelligence, do we get legal rights and responsibilities? It's interesting, and I think that my instinct would say not, but then we have given certain rights to animals. We give rights to humans who are unable to think they're protected by the courts, who when they've had severe brain injuries, even people left in vegetative states have got rights. Some of these computers, some of these AI systems will have, in effect, sort of more agency than somebody in that condition. So some philosophers are saying, well, why wouldn't they then have the same rights that come with that?
Yeah, in due course it could be seen that could develop. At the moment, I think possibly, would you agree that the issue is probably its title? The idea of intelligence in the artificial intelligence, it suggests some sort of thinking, some sort of human function, whereas really what we're talking about is AI is a big data center and a big data processing service, isn't it, at the moment, with a processor at the end of it?
Yeah, there's no thinking occurring is what you're saying. With all of the irrationality and the creativity that might come with that. It is data that is being put in, and it is data that is being spat out. And yet it is giving the sense of, and it's very good at giving the sense of that what is being the output from an AI does look a lot like the work of a human, and actually often is better than the work of a human. No typographical errors. Save, I don't know if you've ever used it, Jason. I'm sure all of your work is original and you charge accordingly. But if you have ever used it to compose an email or some wording, it tends to use. Perhaps I've just got to change the settings. It always tends to use the American spelling. So there's lots of Z's in there, and the organisation is with a Z, and all of the stuff like that. So I always have to tweak it whenever I've used it to sort of make sure that it's spelling stuff correctly.
Yeah, from what I've seen of it, you often can't see the person's style behind it because it's a robot effectively. And you're right, there's the spelling issues, and sometimes it's not always quite accurate, or it uses colloquialisms or other more like the language you might use in everyday life rather than what you might write professionally.
Listen, it can learn that stuff as it goes along as well, and you can tweak it and ask it further questions so it does pick up on a certain style. But ultimately, to go back to your original point, there isn't any thinking that is occurring here, and it probably is the thinking at which point we would perhaps give it a sort of set of rights. That doesn't mean, of course, that there are no responsibilities.
And before we get into the sort of responsibilities that are already there, it's probably useful to talk about regulation of this. And we've already touched upon it here, where we've said, well, okay, there are two schools of thought, aren't there? One is heavy regulation, and that seems to be the way the EU are looking to do it. And do you want to talk a bit about that first and what that might mean?
Yeah, I mean, I brought a note with me today, and the EU have already got, it's in the early stages, but they've got draft directive that's already out there. You can look it up yourself, and it is like, as those of us who've practiced for a while are familiar with EU legislation, there is a set of guiding principles, which is how EU law is typically drafted, as opposed to English law, which is or common law systems where it's very specific. And if similar to the GDPR, they've created a number of rights which are human agency and oversight, a number of guiding principles which are going to effect govern the rest of the regulation. They did something similar, if you remember, with the GDPR in relation to data protection. And those are human agency and oversight, technical robustness and safety, privacy and data governance, transparency, diversity, non-discrimination and fairness, and social and environmental well-being.
So those are the pillars, if you like. Those are the sort of key parts, where the areas that they're going to focus on. And then within that, we expect to see regulation for each of the pillars, don't we, and to differing degrees.
Yeah, that's normally what the EU does. It will then have the general principles and then get into some very finite standards and regulations in relation to what that specifically means. And, that will impose, I would imagine, quite a sort of heavy regulatory burden, which is already there when it comes to the GDPR. And I think it will be similar regulation to that. It looks like the UK is trying to do something different. Insofar as what at the outset, what it's trying to say is actually we don't want a regulatory model. We want stuff that is more guidance and best practice. We want light touch regulation of the sector, and we don't want to burden ourselves with lots of hardcore restrictions or anything that's going to get in the way of the AI being a sort of growth factor in the economy.
And in Europe, what's going to be the thing that regulates it, and how would that compare to the UK? What difference would people be expecting to see there?
Well, the Commission's already established a regulatory body that a commission on AI, which is going to be the driving force and is ultimately going to be the body that's coming up with the regulation. We are doing something similar in the UK, have already set that up, but is more, in some respects, meant to be tasked at, as opposed to coming up with rules and restrictions, is meant to be positively facilitating the use of AI, sort of trying to push data centers, cloud storage, and that, and those sorts of facilities, as opposed to sort of coming up with a set of rules.
And looking at it at the moment, it looks then, so that will be the two ways that it's dealt with in terms of how it's brought in and the rules and the regulations that come around it. But I suspect we'll see that in Europe it will be very courts-led. So it will be statutory, and therefore to enforce the rights or to enforce compliance, it'll go through the courts.
It'll end up in the ECJ. A lot of it will.
Yeah, absolutely. Whereas here in the UK, that's probably going to end up with the regulators, isn't it?
I think we're going to get a sort of. You can see whereby there's an ombudsman body. I mean, of course, we already have this. Again, going to be an analogist the whole way through this podcast today, but we have got, when it comes to the GDPR, we've got the ICO, who has actually got some reasonably sharp teeth, right?
Yeah.
And indeed, some of this, I suspect, will fall into the General Data Commissioner's responsibilities anyway, because that's one of the data protection and privacy is one of the challenges that AI poses.
And in terms of all of this, I think it's probably worth saying to anybody watching this that actually don't take it in isolation, because a lot of AI, all of it's using computers and processing units, and that data is then going to be on and through the internet and various other links. So the risk is you could be using an AI bot here in the UK, but actually that might be subject to, it may sit in another country, so you can't just distinguish the UK from a European country or even from an American state.
Your data potentially, I mean, again, GDPR dictates that EU citizens' data is held on, their private data should only be held, or there should be attempts made to ensure that it is held in countries which have got similar, data protection rights, and one of the big changes of the GDPR was to try and make sure as much as possible that it was kept with the personal data was kept within the UK. But you're right. I mean, if you are using all the big social media providers, data centers, while some of them will be in the EU, there are American companies, and a lot of them will be in America and other jurisdictions where the rights are completely different.
And it's probably lending itself to this idea of a global economy, isn't it, in due course, where whatever you're doing doesn't necessarily mean that you're on home turf to do it, even if you're physically sat on your bum in Birmingham or wherever. You may well be treading on international laws.
I mean, listen, sounds like the sort of thing, it's a proper jurisdictional clash that could occur. We might say good for lawyers, right? But
and just so we're aware, jurisdictional means?
You're getting me on that for once. But jurisdictional, jurisdiction means which courts have the right to determine the issue. So in England, that would be the courts system in England and Wales. Actually, it's slightly different in Scotland, who's got their own court system, and Northern Ireland has got its own court system too. But is this going to be determined in under English and Welsh law, or could it be under American law? And truth be told, even when you talk about American law, most of the legislation over there is dealt with at state level. So whenever you've had a dispute with involving American companies and American law that I've been involved in, it'll be the law of Florida or the law of Los Angeles. The law of California. Their courts, state specific. It's a bit actually on some respects. Even though it is separate countries, the EU has got this overarching power and responsibility of the European Courts of Justice, which are the final arbiter of anything really that's got any kind of cross-border element. And again, as you said earlier in this piece, they're going to be the arbiter of everything in relation to the any legislation that comes online in terms of artificial intelligence.
And I suspect it's going to be a very interesting and changing time. I mean, we're already seeing it with things like email, where, the acceptance of a contract, where did it take place? So it's by email. Oh, it's in both, simultaneously in both countries, so either country could take it. I suspect with the development of AI, there'll be more of that in due course.
I mean, we've already got that with those challenges for a number of years now. We've had what's called a smart contract, and a smart contract often uses very complicated algorithms known as the blockchain, which can mean that contractual terms can be changed across multiple contracts by the click of one button, often by the service provider. Under ordinary principles of English law, in terms of a contract, there has to be an offer, there has to be an acceptance, there has to be consideration. If somebody's changing a contractual term on a computer, at which point has anyone accepted that change? Normally a variation needs to be agreed by both parties. The smart contract technology means that can happen whether the receiving party agrees to it or not. Is the clause that they've changed there, is that then a viable, or can that contract change be upheld? No doubt they will have clauses in the contract that says we can just vary the contract at will, but as a general principle, that isn't how English courts have allowed contracts to be varied over the years, and it's going to create an interesting challenge.
And I suspect it's probably going to mean that people do need to look at the terms and conditions again in due course to make sure that they are picking what jurisdiction, what country will deal with it, which courts will deal with it in due course, isn't it?
Yeah, I think it's really important with your suppliers, particularly if you've got anything that's going on in multiple jurisdictions, to agree what is going to be determined where, and to have that in your contract and to give it some thought and try and agree that with your suppliers and your customers and have it in writing, and ideally have some kind of evidence of consent, whether that be a signature or an electronic signature or something that's unequivocal that has both parties agreeing as to what the jurisdiction is.
And to move things sort of forward and on to the next topic, we've talked about AI, we've talked about what it is, we've talked about where it's sort of going and what it looks like. It'd be fair to say that regardless of whatever the new rules or regulations or legislation, or however the government and all the relevant bodies decides to bring that into play, it doesn't stop it from already having some existing bases and legislation and law that's already there that it applies to it. So, for example, you've already talked upon GDPR, so it's probably useful to start there. GDPR is going to apply, isn't it?
Yeah, so GDPR, and you'll often hear people use.
And just to take a step back, GDPR.
Oh, now I can't even remember what it stands for now. It's General Data Protection Regulation. So it's the law. It used to be called Privacy Law, but then everyone started calling it GDPR, which is sort of naming the law after the legislation. In effect, we did have a piece of data protection legislation in the UK, Data Protection Act. I think it was 1998, and it's sort of it's very similar to the law that was there. What it's trying to do is to make sure that people's personal data is in effect safe and secure, so it can't be hacked and used for any kind of identity theft. That your most personal data, if it is being used, or to use the language of the legislation, processed, that it's being processed in a way that you have given consent to. And the big change when they introduced that legislation was that in the past, most of the consent, or a lot of the time, people would try and argue that it was consent by implication. That I've given somebody my personal details for whatever. I'm ordering something online. Therefore, the implication is that I bought something from that company. It's implied that they can use that data to sell me something else.
And now it's all about legitimate interests rather than pure consent, and pure consent being actually, yes, I've said you can use my data for this, and it's very specific.
Well, you need it, it's around express consent and having a legitimate interest for using that data, and not using it for purposes that the person hasn't given that express consent for. This is where it gets interesting for the when it comes to artificial intelligence. So I am told lots of people, lots of the AI bots have been trained on data that is out there in the internet.
And when you said trained?
It means that it scans it in, it gets the software to sort of read and understand what's being said. So again, if it would look at lots of online recipe pages to work out how you cook a chili con carne.
Yeah.
And it would know the different variances of chili con carne and what you needed to do for a spicy chili and what you needed to do having with a mild chili and everything in between. Now, all of those people who have published their online recipes, to the extent that they are original works, that they're special secret, they've done something slightly different, so that it's got that scope of originality that is protected by the law of by the law of copyright. If the AI bot is reading that in effect to train it to be trained so it knows and can recognise what a chili con carne is, well, actually, it's reading the work or the data that is owned by somebody else. Now, that's one thing for chili con carne, which would be around the law of intellectual property, but it's something quite different when it is people's personal information that they've given over for one purpose, and now all of a sudden that's been fed into the AI bot to work out all sorts of different things.
And again, with personal data, you've got a potential issue as to where it's been stored, haven't you? Because if you're suddenly shoving data into an AI bot, and that AI bot's now based in America, suddenly you've disclosed and used data and sent it to another country, haven't you? So
and it's much harder for you to enforce your rights in a different jurisdiction,
and potentially have created whoever the owner of the AI bot is some sort of property in that data, which was never intended when the data was given over. So I think what we're saying here is that actually, yes, AI has its place, and yes, it's there, but those who are using it have got to be very careful as to not breach the GDPR.
And I think that what a lot of what some of the software companies have realised is that is a challenge, and one of their workarounds is in effect to try and use technology to anonymise the data, so that even if you wanted it to write a letter of resignation, I'm writing my letter of resignation to you. And if I put your name into the chat GPT, and I put your job title and even your address and where you work and all of that stuff, I mean, I'm using your personal data and my own personal data when I'm drafting that letter, and it will draft me a very professional sounding letter at the end of it. Some of the providers, I certainly know that this is true of the Microsoft products, Copilot, and I think some of the Apple Intelligence software, it will never send it. It recognises that Jason Alcock is a name, and that does not leave your device. It's an anonymised name is sent into the cloud. When it comes back with the answer, it knows that the anonymised name, the pseudonym, is you, and the device then does something so that it is written as a letter back to you. So the data, your name and that personal data, often will not, as some of the existing technology, will not leave the device that you're using it on.
Which in turn means there's probably other challenges about what have you installed on your computer and what's it doing, potentially. Because there must be some encryption or code that's telling it to do that when it's coming through that gateway.
Yeah, I mean, yes, but I think it's less challenging if that personal data is not leaving the device that's sat on your desktop or is sat in your hand. I mean, that is you own that. If it doesn't get sent out there, then I don't see that as challenging. That's one of the sort of workarounds that the software providers have come up with to try and stop, GDPR breaches in effect, or data protection breaches, so that actually your personal data is not being sent into the cloud, is not getting sent to the United States of America or anywhere else in the world where you would have difficulty enforcing your data protection rights. I do think that that's a more recent development, and I'm told that a lot of the software, the AI bots as they're often called, has been the information that is already on the internet. It's been sending its bots to read that data and use that data, and the law will catch up with that eventually. But as it stands, where there is an absence of regulation, some of that is perfectly lawful, and and even if it's not, they're not telling anyone that that's how they've trained their AI bots. So very difficult for anyone to find out. Very similar to sort of the early days of the internet, when there was a lot of copyright infringement around musical works, Napsters and LimeWires and all those companies were in existence. Lots of copying of people's photographs and images, which was made very easy by the internet. Right click, save as, use that photograph, on your own personal web page. I mean, that was copyright infringement, but it was very, very seldomly, until relatively recently, was very seldomly enforced.
And I guess that's sort of the next thing to come on to, isn't it, really, is the intellectual property rights. And as you've already alluded to, feeding this information into an AI bot so that it can do whatever it is it needs to do. Potentially you are going to breach copyright, aren't you?
Yeah, I mean, AI and intellectual property is an interesting concept. When it comes to copyright was able to deal quite easily with the internet without any real sort of changes to legislation. They weren't needed. It had already, even as late as 1988, it had worked out that computer programs potentially could be used to write code and be used to write works of art, and that if the code or the works of art were copied, and that being the key test, or the key thing that you're not allowed to do without permission, if they were copied, that your copyright could be enforced. So if you were downloading from Napster a song, a Metallica album or something along those lines, which I'm sure you did, Jason, back in the early 2000s, if you did that, well, actually, that has been copied from the server, wherever the Napster server was, and was being downloaded onto your device or onto your computer. And that act itself was copyright infringement. Now, there is a question about how the software works when these bots are scanning works and literary works, contents of a website article, for example. By copying that and processing that and using that, there is certainly an argument that is that's an infringing, that you are infringing somebody's copyright there. And certainly, if you were to if there was a website with an article that was being used to promote a business, and you've copied that, fed that into AI bot, and said, make a version of this as different as possible that for my own purposes of my own business's website. Rival law firm, they've got a really good article up on artificial intelligence and the law. We copy and paste it, feed it into the bot. We haven't done this, by the way. Feed it into ChatGPT, and we wouldn't advise it either, and say, make a more business-friendly or more readable version of this article, but please change the name ABC Law to Ansons Solicitors. ChatGPT will definitely do that for you, but that would, in my view, be an act of copyright infringement. Maybe hard to prove that is what's happened, and that's a sort of separate area, but that would be copyright infringement. I think that where it gets more interesting and challenging is it's one thing to, and the law is pretty clear when it comes to wholesale sort of plagiarism or copying of works. Slightly different when you're copying concepts. As the law as it stands, if the works of J.K. Rowling, the Harry Potter series, if I'm an author and I literally maybe change some of the words, but get the text, copy that, and come up with my own version, and I'm just changing lots of the words, almost every word, to a slightly different one. Don't call Harry, I don't know what we'd call him, Larry rather than Harry. It's very obvious to point at copyright infringement. As it stands, however, even if another author was to come up with a very similar plot with the concepts of the plot, with a young wizard who goes to a private school and has got, a couple of friends and a giant who looks after him, and an elderly wizard's in charge of, is the headmaster at the school. I'm impressing you here with my Harry Potter knowledge. I've only watched the films. I don't think I've ever read the books. But that plot is capable of copyright. That would potentially be copyright infringement if somebody did something extremely similar and used Harry Potter almost as the what they've followed here. However, the bots that you could come up with, you could say in the style of J.K. Rowling, or write me a plot for a new book about a wizard in the style of, and it could do that. And then there's a question of is that copyright infringement?
And just so we're clear, who's liable for all of this at the end?
Well,
liable meaning responsible.
Well, the software providers are currently saying it's you, the user, the person who's given the prompts. Now, whether or not we could see some kind of secondary litigation, regardless of what they're saying in their terms and conditions, whereby a high-profile author or a high-profile musician could actually say, hang on, all of these Taylor Swift sound-alike songs that clearly people have been feeding in prompts of, create me a song that sounds like Taylor Swift. That you could see how she could, or a significant artist could.
It's the Metallica Napster thing again, isn't it? It's they've copied it, they've done it at that point. It's the thing that is doing it, the thing that owns the bot that's doing it could also be online, but the person who's pulling that or using the end product could also be.
Well, both of them, I would say. I mean, when it came to Metallica and Napster, they pursued both, right? They pursued both the end users and they pursued Napster themselves. Napster's argument being we're just a platform, which is almost certainly what the AI providers would say as well.
But we can see that could develop quite easily, couldn't it? But I think the point to take from it is if you're going to use AI, don't think you're going to just sit there and hide behind, it's a platform, because it's not likely to work.
There will be copyright infringement claims that are made. And I guess what may well happen is that the prompts that you're fed into your chatbot will be disclosable. and that might reveal what precisely you have done.
Yeah.
And so that, the internet never forgets, and I'm sure whether it be on your own personal equipment or somewhere at the chatbot, there's probably a record of what you've asked it to do, and it might well be that that's something that's disclosable in litigation and will be the determining factor. Years ago, there was a copyright case recently. Ed Sheeran and he having alleged to have copied the song or the composition of somebody else, and in the end he was found not to have infringed that. In those cases, they didn't have the evidence of the chat, the prompts that are fed into the chatbot that says, make me create a song that's very similar to one of Ed Sheeran's popular hits.
And I guess in that we're touching upon another area where we're saying, look, there's already rules and regulations in, because we've got the disclosure rules in the courts, the CPR, so the civil procedure rules that tell us how we have to deal with a case and things that are disclosable, i.e. you have to present them to the other side. And that's going to play in, isn't it?
Yeah, no, exactly that. And I mean, I think we will find that, generally speaking, there's probably enough law out there already that will capture a lot of this. I think that a bit like the early days of the internet, unfortunately, in the early stages, there's going to be it will be like the Wild West, and in some respects just flagrant infringement of copyright and use of other people's works. And if the government is going to do something, legislate at all, it should be protecting people's intellectual property. And I know that there's some new employment law reforms coming in next year, and it'll be interesting to see, if it is going to, as part of that, actually have the to be an intellectual property element, so that workers' creative output isn't just fair game to be copied and used by internet, by AI bots, and AI algorithms. We will see.
Indeed. I think what we can take from all of this is, look, AI it's already here, isn't it? It's already being used. Is it anything new? I mean, looking at particularly in our industry or industries that you've worked in, is artificial intelligence is it a new concept, really?
Well, when it comes to the law, I would say certainly lawyers need to be careful. Starters, in terms of their clients, they've got a responsibility. Ignoring the general law on privacy, they've got quite a high professional obligation when it comes to client confidential information. And client confidential information should not be being fired out into the internet so that you can write a quick letter or to help you put together an argument to present before a court. Lawyers need to be really careful when they're doing something like that, and basically they shouldn't ever be putting any client private data, using it at all in a chatbot of any kind, an AI bot of any kind. In terms of it generally, I would actually say that lawyers have used precedents. They used to be in big books. We've still got some of them. The Encyclopedia of Former Precedents, which sits in our dusty bookshelves in the library of our Lichfield office, which makes for a good backdrop to some photographs, but I would imagine have not been used for many years. But lawyers have always got templates that they would use. That went on, and we started using online templates. And so there is nothing new in that regard, and often would it quite heavily inform. We did a podcast discussing an employment law contract, and we printed off an online, one of the standard precedents that we've got access to that we typically edit to make it fit the situation of our client's specific case. The difference will be the approach to that, because I think you will be able to use a chatbot to say, if you were drafted an employment contract, there's how many hours a week the contract was for, any variances, just by answering questions that the algorithm may put to you, or indeed you input into it, so that it can draft it for you. I suspect at the end of that it will produce a contract or a form of contract, and you're going to have to heavily review it to make sure that it is compliant. But again, is that anything that different to what lawyers have done for years? I don't think so. It's just a sort of perhaps a more user-friendly form of technology, and as I said, with some potential pitfalls when it comes to client confidentiality and your obligations in respect of client data.
It's a tool, effectively.
It's a tool which will hopefully speed things up a little bit, and hopefully there'll be a benefit in the long run, which is something I know that the government is keen to see, to consumers if it can speed things up. There's already been substantial use of technology and algorithms when it came to disclosure, which often on certain cases is a big part of the case and a big part of the costs. And technology can be used to, in effect, extract the relevant documents from somebody's computer database, from somebody's email account, so that and to do that without an individual lawyer spending thousands of hours just reading every email that's come in and gone out of somebody's Outlook. And that's something that the technology that's been used there has been used probably over the last sort of 10, 15 years, and is quite sophisticated now, quite user-friendly, and does help up to a point to keep costs down. I mean, it's always a double-edged sword, because it does enable you then to look at a lot more data as well. So, on one level, several years ago, you might go and pull out a couple of files in a filing cabinet when you're doing disclosure for a client. You now potentially are searching with certain keywords the whole of their email database. So, whilst it can do all of that a lot quicker, it does expand the scope and the size of potentially what you can do.
And just to sort of round off the whole thing, then, do you have any words of warning, or words of not advice but guidance for people that are thinking about using AI? And I don't mean lawyers; I mean generally.
I mean, it as you said earlier, as you just said, it's a tool, but it isn't a tool that gives you some sort of invincibility cloak from the law generally. So if you are copying somebody else's work, if you are using somebody else's private information without consent, the law still applies to you. And so as with anything, you have to be careful, and not just to think that this is the Wild West and I can just get away with whatever I want, because the history of the last sort of 25 years and the increased use of technology has shown us that eventually the law will catch up with you. So I definitely would encourage businesses to use AI, but just to be mindful of their existing rights and responsibilities to their staff, to their customers, and to themselves.
And probably just as a final note, it's probably worth going full circle to where we started. AI is a system, a processing tool. It doesn't necessarily mean it's always right. It is taking data, it's processing data, it's turning into something that might be useful, but that's not always 100% accurate. It's not always correct in its context, and let's be honest, if it's drawing from the internet generally, there could be lots of misinformation.
Yeah, I know what you're leading to here. If you've got a question, do not ask ChatGPT. Pick up the phone to us and we should be able to answer it.
With a bit of luck.